Michael Anthony Arroyo.
So Arroyo, Judge.
Arroyo, okay. Come up.
This was the matter that there was a,
Yes, I remember it.
so do I.
All right, where is he?
So Mr. Arroyo is present.
Come forward.
Mr. Edelman is suggesting that he needs 2 weeks to review some video to confirm.
Recordings, it seems that there's may be a recording in the possession of SAPD that has not been produced. I have not had an opportunity in requesting it.
All right, so is that recording going to be something that tells us the person, the identity of the person driving the vehicle?
I don't know. I won't be able to say whether. And that's why I want to have it in order to review it to see what.
All right, Ms. Ferguson, recall this for June 16th.
Thank you.
Thank you. Once you sign the reset form, you're excused.
Put on today's docket?
Yes, it should be. All right, Curtis Wilson,
Yes, Judge.
where is he? Yes, counsel.
Judge, I believe we're set for a pre-trial hearing today.
Yes.
I've lost a minute in my office, so I can't confirm that you even received the motions.
I'm sorry, what?
I've lost my internet stuff and I'm all digital. So when that happens, I'm.
All right, we can recall it for tomorrow for motions.
Okay.
All right, Ms. Ferguson, Wilson is being recalled tomorrow for pretrial motions.
Yes,
All right, just have a seat. They're gonna give you a reset form. Once you sign it, you're excused. Who's here? Larietta Holmes?
Good morning.
Good morning.
Judge, we're here this morning just to set a bond. It's a deferred case. The MTR right now is set on Thursday. I checked with probation this morning. They don't have the report ready yet, but hopefully we'll be able to resolve it Thursday. There may be a small chance I may need some more time depending on, I'm trying to get some information for us.
So you're requesting a bond?
I want to see if we can get a bond set. while we're
All right,
here.
have you conferred with the state?
I have
All
spoken
right,
to Jason.
it's calling 2024 CR 2336. Everyone needs to whisper. State versus Larietta Holmes. Can I have parties announced?
Jason, do you have the state you're on?
John Robertson from his Holmes.
And are you Ms. Holmes? Yes. All right, defense is requesting a bond. You're on deferred adjudication, so you're entitled to a bond. Have you all reached an agreement on a bond amount?
No agreement, Your Honor.
All right, state, what are you requesting for a bond amount?
Previously, the bond was, Your Honor, and the state is requesting 30,000.
All right, defense, what are you requesting?
I request court to consider 5,000.
Do you want to call your client as a witness for purposes of the bond?
Sure.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. You're gonna need to speak up so the court reporter can hear and so I can hear.
Yes, ma'am. Larietta Holmes.
All right, defense, you may proceed.
And Ms. Holmes, you're in custody pending a motion to an adjudication of guilt on the case, right?
Yes,
Okay. Before you were arrested, were you working?
yes, I
What,
was.
what kind of work were you doing?
I'm a licensed esthetician.
And do you also receive any other type of assistance?
Yes, sir.
And what is that?
I received SSI's, benefits.
Okay. And if the court were to set a bond in this matter, you understand that would potentially, if you're able to make the bond, we would still have to come back to court for the motion to enter adjudication of guilt. Do you have funds available to where you could post bond?
Yes,
Okay, understanding that a 10% that the bondman might be necessary, do you have funds available to post a $30,000 bond?
not 30,000.
You have funds available to post a $5,000 bond. Is there any other family assistance that you would be able to rely on to come up with money to post bond?
My spouse and my,
That's all I have. now.
All right, any questions, state?
Yes, Your Honor. Previous bond was at 15,000, is that correct? And did you make that bond?
yes.
And why was your bond, why were you remanded with that bond?
Honestly, I don't know. I just remember it's not bond. They just came to pick me up.
Okay, question, John.
All right, this is what the court is gonna do. The court is gonna set your bond at $30,000 and there's to be no contact with the elderly or the complainant in the new allegation. All right, Ms. Ferguson, if you give a reset form, please. They will be back on Thursday,
I think we're already set Thursday, Judge.
but she doesn't have a reset form. I want to make sure she has one.
And Judge, if we need more time, can we address the court on that on Thursday?
Yes.
Thank you.
All right, who's here on Paul Marceau? Have you conferred with the state?
We have, Judge.
And do you have all discovery?
We thought we did, Your Honor, but spoke to Mr. Garahan, there's a note on the file about there's an EDU disclosure on one of the officers that we don't have yet. Garahan's gonna get that to us.
All right, Ms. Ferguson. This is gonna be recalled back for July 7th for discovery update. Mhm. All right, other than that, is there anything else that's missing from discovery?
Nothing on that, no, not on that case, Judge.
All right, and then he has a motion to amend bond conditions to allow for travel. State, are you objecting?
Your Honor, at this time, from the facts of the case, I don't have an objection, but I have not been able to contact the complainant to see if she attends that church or is around that church. We
All right,
just-
so this is a narrating of arrest, detention and vehicle. That's what I have. Is there something?
There's another case, Your Honor, that's unindicted still.
All right,
I filed a motion in both cases, Judge.
all right, could I see the motion on night mag number 701641, unless you have a copy?
That one, right? And it's for travel, it's a bond modification so that you can go to church, Your Honor.
All right, and state you're gonna have an objection?
No, we do, because we haven't been able to contact the complainant to see if she attends that church. There is a no contact order in place. Which I just haven't been able to confirm that. This is the first time.
All right, when do you want this set? When will you have the information and we can set it for motion to alter bond conditions?
Your Honor, if we could just maybe call it back later this week. I've already sent out the call and email to.
All right, you want to come back on Thursday?
Yes, Judge.
All right, Norma, recall this for June 5th for an update on the bond issue. And then at that time, I'll give them, well, I've already given them the date of July 7th for discovery. All right, and then the bond matter will come back on Thursday, June 5th. So if you can
June
give them a reset form, please.
Thank you, Judge.
He doesn't have an objection. Order.
Yes.
Thank you.
Thank you.
Thank you, Your Honor. May we be excused?
Yeah,
pending-
put your sign
Thank you.
reset form.
Thank you.
Thank you.
We're gonna take that motion back, is that okay? Sorry. Let's keep it's.
Yeah, but if you'll make sure that they have it next time
We'll
with
do,
the
Judge,
clerks in
we'll
the
do.
back.
Yeah,
Okay.
sorry, Judge.
All right, thank you. All right, who's here on Roger Blanco? And where's Mr. Blanco? Come down, please.
Have two motions, Judge.
All right, so are you requesting a withdrawal?
I am requesting a withdrawal, but I would first like to hear before I withdraw, just motion to set. I'm not on the first agreed list, Judge, and this got filed as habitual.
All right, so then I can't go forward with any other motion. It's gonna have to be the motion to withdraw. Then we'll appoint an attorney to represent him and they can hear the remainder. All right, so the motion to withdraw is granted. Sir, just have a seat. We'll make sure you get an attorney.
And I'll go ahead and find out who it is and I'll,
All right,
Cover
thank
that.
you.
we have excuse, Judge.
Yes, oh, we're gonna give him an attorney today.
Okay, thanks.
All right, Norma, he needs an attorney. And we have attorneys who are here, so that's a good thing. All right, Adrian Ramos. They're gonna recall you back on Monday. Your attorney is currently in a jury trial in another court. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Thank you. You're welcome. Who's here on Jonesha Walker? All right, if you come forward. Where's your client?
Please come up, Judge. I'm here for Elizabeth Russell.
Okay. Hello, why were you late for court?
I was here.
No, you were not. No, you were late. I called your name. You were late.
I was outside the courtroom.
All right, so court is inside. So court starts at 9 o'clock
Yes, ma'am.
and you need to make sure you're here. Otherwise, a warrant's going to be issued for your arrest. Do you understand?
Yes, ma'am.
All right, so where we state on discovery on Jonesha Walker. I don't know if this is criminal trial division or family violence.
It's CTD, Judge.
Yes.
I'm not sure because I'm covering for Elizabeth Russell, but we did get our first offer today.
Okay. How old are you?
29.
All right, Ms. Ferguson. Set this for a plea deadline date on July 7th.
Yes, ma'am.
Thank you, Your Honor.
All right, once you sign the reset form, you're excused. Thank you.
Thanks, Judge.
All right, who is here on Malik Lampkin?
Because we need to get an update to the courts
Okay,
from the Center for Healthcare Services. Those people are here.
all right, so what is happening with that? Hi. Hi.
I'll let you talk.
So I did talk with Molly, last week, right? About last week. And he does meet criteria for substance use disorder. And he did tell me that he was agreeable to go to real time if that was an opportunity that he would have. So. Yes, he does meet criteria.
All right, so,
Have him there by this week, next week at the latest, but there are some beds available right now.
all right, so this is for the motion.
It is supposed to be for the motion to revoke, Judge, but I don't think the state and council have had an opportunity to work that new case out. So we would ask that this, if we move forward today with the lifetime recovery, that be added as condition of his bond.
All right, so we can add the, like, has he made bond on the new charge or no?
Have we made one?
I think maybe he's talking about the hold on the motion to revoke because if he's on a deferred for that, then he may have a hold. So if you want to talk to or with the state, thank you so much for being here with your update and everything. I truly appreciate it and moving things quickly. I like that. So if you can speak with the state, then we can see about setting conditions of bond and you say lifetime.
Yes, ma'am.
And then we'll set the bond with the condition that he go to lifetime recovery to address the mental health as well as any other issues.
And my understanding is that if he's out on bond, if he's at lifetime recovery, he'll be brought back for all his court dates.
Okay, all right, if you can confer with the state
I
on
will.
that, and then we'll take care of it.
All right.
All right,
Thank
thank
you,
you.
Judge.
And are they also here on Mr. Payne?
Yes, on Mr. Payne, Vanessa,
Can I see the file on Payne?
Mr. Payne and Ms. Silva.
So
Not yet.
Yes. Okay,
Yeah.
so I did talk with Mr. Payne and we were in process of getting him a screening with ACOG that's in the jail. However, when they went to go visit with him, he was in the hospital. So we're gonna have them meet with him. I just sent them an email letting him know that he'll be over there sometime today or tomorrow.
All right, Mr. Payne? Hi, if you can come up for me, please. How are you doing this morning? Good morning. How are you doing? Oh, thank you so much. So they said they came to see you, but you were in the hospital. Are you doing okay?
Yeah, I have so much. Where did I go to hospital? When I had a seizure, in in clinical observation. For the first time I ever had seen it.
All right, so when do y'all think you'll be able to see him?
I'm gonna try to see if they can see him this week. We also did talk with his brother,
Mhm.
which his brother said that he was willing to have him come back under some certain conditions as far as him being stabilized back on his medications again, which he also agreed would be good for him. And then, but also to have that follow-up care as well. So his brother had given me the names of all the medications that he was on, and he was on that injection
Mhm.
that usually lasts about a month.
Mhm.
So we're in the process of reaching out to university within the jail. And I also brought some people from Corazon Ministries that are helping me.
Thank you so much. Oh, come on up. So what I'm wondering then, can we recall it for maybe well, 2 weeks? And then if we're gonna recall you in 2 weeks, okay? But if they have information for you before the 2 weeks, they can come in anytime and we'll put you on the docket anytime.
Yes, ma'am.
All right, so what date are you all thinking?
Well, we're in the process right now, but I know that, here, Russell. Yeah, so Russell had this great idea and we
Yes.
talked to Mr. Payne as well, and he was also agreeable to work with True Mental Health if we can get everything sorted out. So then we're just trying to figure out that part. So along with the ACOG services, because they can also help brother and him and also do like in-home visits, but True Mental Health also does that stuff too.
Well, what I can tell you all is I'm not gonna be here the week of June 16th because I'm doing a CLE. But if y'all wanna do something, I don't know if you can do it by Zoom. Yeah, we can do it. I can put him down for June 23rd. Mr. Payne, if they have everything worked out before June 23rd, all they have to do is let me know and I'll figure out a way to make it work.
Okay.
All right, I tell you what, let's do this. If everything is worked out before June 23rd, since Judge Rangel does the mental health court, which I know he doesn't qualify for, I'll ask Judge Rangel if he'll hear this matter since he has mental health court experience.
Love that idea.
All right, so we're gonna put you down for June 23rd.
Okay.
Ms. Ferguson,
Yes, ma'am.
Mr. Payne, we're gonna call him back for June 23rd, but if they have everything completed before then, and if it's completed the week of June 16th, I'll ask Judge Rangel if he'll hear it.
Yes, ma'am.
All right, is there anything else?
No, ma'am.
All right, thank you so much. Continue doing what you're doing, okay?
Yes, ma'am.
And take care of yourself.
Okay, thank you.
All right, thank you.
Judge.
Thank you guys so much.
I got it.
Miss Silva, maybe very similar.
All right, let's bring up Miss Silva. Could I see the file on, oh, here she is. Oh, I have it. It's on Silva.
Thank you, Fran.
Hi.
Good
Okay.
morning.
Good morning. You're looking healthier.
Thank you.
All right, so what's going on with Miss Silva?
So I spoke with Miss Silva last week, right? And so there is no, she does not meet criteria for substance use disorder. She's been a long time, really proud of you for that. And so what we were thinking was also getting her screening with ACOG as well, getting her set up with that and seeing if we can get her back into another boarding home, right? What you wanted to do? Yeah, so they will help with that facilitation as far as getting her set up with that.
All right, so then what we'll do, we're gonna reset you for June 23rd. However, if everything is completed before then, if it's completed by June 16th, I'll speak with Judge Rangel and see if he can hear these two cases, okay?
Okay,
So-
if that don't work, can I please try going to the neighborhood?
All right, so this is what I believe in. I believe in building bridges as we come to rivers. So we're gonna see what happens with this. So let's 100% focus on this. And if this doesn't work out, then we're gonna see about something else, okay?
Okay.
Now, just know if you come back on the 16th, they're not gonna bring you to this courtroom. They're gonna bring you to the courtroom across the hall, okay?
You know what number that is?
Hmm?
What number is that?
Oh, it's 379th. All right, thank you.
But we're talking about June the 23rd.
Yes, she's set for June 23rd, but similar to Mr. Payne, if they have everything done by June 16th, it'll be with Ron Rangel.
I have a quick question for Ms. Silva. Do you
Sure.
have identification and social security cards?
I have, it's on my own working model, let me go back. Okay. If you want, I can give you the address. But
You've been here in Vancouver.
all my life.
So if anything, you know, as far as like safety net, right, like a backup plan would, Russell with Clarkson would be able to try to facilitate that into Haven if we can't get another boarding home or anything situated. We'll figure something out.
Okay, all right. All right, thank you. All right, who's here on John Thornart?
Hi, Your Honor. Morning.
Good morning. Good morning. All right, so you're actually scheduled for a jury trial.
That's right. And Judge, really quickly, I'm sorry to cut you off, Your Honor, but this was also about receiving discovery. It was a setting for that.
Yes.
I did retrieve the external drive this morning.
Mhm.
Just talking to Mr. Edelman. I had not gotten any type of notice beforehand. I'm not saying that that's an issue with the
Mhm.
state. I just had not received anything like that, but it was there waiting for me. So I have not yet reviewed it, Judge, but but I do have it in my possession now.
So you need time to review?
I do, Your Honor.
How much time are you asking?
At least 2 weeks, Judge.
All right. Ms. Ferguson,
Yes, ma'am.
set this for, you want to do it the week of June 23rd?
Sure.
All right, could you set this for the week of June 23rd, and that'll be final discovery?
Either day is fine.
All right, so you'll come back on June 23rd, and that will be the final discovery date.
Yes, ma'am.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Your Honor. Appreciate your time. Good Judge.
All right, you too. Number, what page is he on? All right, thank you. And Mr. Thornhart, you need to make sure you're on time next time.
Yes, ma'am.
And I'm sorry, Your Honor, he was outside. I had him wait. I do apologize for that, Judge.
All right, let him know he needs to be inside.
Sorry about that, ma'am.
No problem. All right, Roger Blanco?
That's me, Judge.
Yes.
Yes. Judge.
Right. You want to have a hearing on the bond motion?
Yes, this is his, I just got appointed to his case. He was on a $10,000 bond. Mr. Aguilera, his previous attorney, his home burned down on 170 Peach Valley,
All right, we'll,
and it was returned for,
okay.
it was shown that
All right, court is calling 2025 CR 002-804, State versus Roger Blanco. Can I have the parties announced?
Jason Garrett from the state, Your Honor.
and Michael Doleon for Mr. Roger Blanco.
And are you Mr. Blanco?
Yes, ma'am.
All right. It appears that the defense attorneys has filed a motion to have a bond hearing. And the defendant, I'm assuming his bond was revoked because he didn't appear?
That's correct, Your Honor. He didn't have notice of it and, but he will make all his court appearances and
Yes.
he hasn't had any problems
All right,
beyond this.
Mr. DeLeon is saying that the defendant didn't receive notice because the house burned down. And so the documentation that his previous attorney, Mr. Aguilera, had was that this address is listed as a vacant lot. So is there a agreed amount per bond or no?
I haven't discussed with anything with Mr. Garahan, but his previous bond was 10,000. We just like to have it set again for 10,000.
All right, and state, do you want to see the indictment?
If you don't mind, thank you, Judge.
State, do you have a bond amount you're requesting?
If the previous bond was 10,000, Judge, the state would be requesting a minimum of $20,000 bond.
All right. Any objection? I'm assuming there's no objection to the court reviewing the indictment.
No objection to that, Your Honor. In the alternative, we would ask for compromise of 15,000 potentially.
And do you want to call your client or no?
No, Your Honor. I think everything's put out in the motion.
All right, then the court will set your bond at $20,000 with all previous conditions. And can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Roger Blanco.
All right, Mr. Blanco, and this is just for purposes of me setting conditions of your bond. Have you ever had any type of mental health issues in the past?
No,
Ever been diagnosed?
never.
Ever been on any type of medication?
No, ma'am.
Any type of drug use in the past?
Yes.
All right, and in the past, what would that have been?
Heroin.
All right, this is what the court is gonna do. The court is gonna set your bond at $20,000 with all previous conditions. The court will add 90 sober meetings in 90 days.
Yes, ma'am. I so object.
All right, and Ms. Ferguson, if you'll give him a reset form, please, for June 10th. All right, thank you.
Thank you, Judge.
You're welcome.
Thank you, miss.
You're welcome. Or whatever his previous setting was, I think June
June
10th.
10th is
Yes.
correct, Judge.
The defendant, yeah. All right, thanks. All right, who's here on Malik Lampkin? All right, no problem. Ashley Jones.
Oh, just wanted to let him know already on Medellin.
Good morning, Judge.
Good morning. All right, where's Miss Jones?
She is not here, Judge. I called pretrial services. The same phone number, there's no answer. I called the bondsman. They gave me two phone numbers. One I already had, and the other one I left a message. And I don't have a response yet.
All right, the court is calling 2025 CR 002136, State versus Ashley Robin Jones. Could I have parties announced for the record? State?
Austin stops the state.
Defense?
Alma Benavides for Ms. Jones.
All right, this hearing was scheduled at 9 a.m. It is now 11:41 a.m. The court called the docket at approximately 10:40. The defendant did not answer docket, and the court has called this case number as well, and the defendant has not answered docket. Deputy Laura, did you make an announcement for Ashley Jones?
Yes, sir. She is.
All right, defense, have you had any contact with your client?
No, I have not, Your Honor.
All right, state.
Your Honor, we're asking for her bond be forfeited on these cases.
All right, that will be granted, and your client will be remanded without bond. If she makes an appearance, the court will reconsider.
Okay, thank you.
Thank
Judge.
you.
Thank you, Judge.
Thank you. Who's here on Byram Mejia?
Judge President, Judge, this matter is set for tomorrow. It's a brand new case. There is voluminous amounts of material.
Mhm.
Some material is maybe inappropriate, so
All right, is your client on bond?
he's in custody.
All right, so what amount of time are you requesting?
I guess another 30 days. The goal is to go see the first tranche of information tomorrow afternoon, maybe 30 days or something.
All right, Ms. Ferguson, I need a 30-day reset.
I can do it the July 7th, Judge.
All right, July 7th.
Thank you, Judge.
All right, thank you. You're welcome.
Maybe just the 8th. So, I'm sorry, I didn't realize this one's out of town. So the 8th would
Right,
be,
July 8th.
thank you, Judge.
You're welcome. All right, are you ready on Malik?
Yes,
Lampkin?
Judge, I've conferred with Mr. Garrahan
Mhm.
and Mr. Garrahan was gonna recommend a particular bond for the MTR.
All right, so does he have any bond on his current case, the 2025 PF 10415?
Yes.
You do?
Yes.
You know
All
what
right,
that
so-
bond amount is? 100,000.
All right, and has he already made that bond? All right. And then on the motion to revoke, what are you requesting the bond? I think he has a bond set on this, doesn't he?
I believe that's the one that, Mr. Dillon was trying to get a bond set.
All right. And have you all come to an agreement or no?
I have a recommendation of $75,000.
All right, so We can go on the record, but Mr. Lampkin, it appears that you're on deferred adjudication for a specific offense. And then this new case is a higher level of the same offense. So I don't see why. And I'm assuming that's based upon what's in violation of condition number 1?
Yes, sir.
All right, so this may be improperly submitted or placed in intake because violation of condition number 1 says theft from a person.
Yes, and then they also, I believe that they, it's also on the MTR, also put it as a robbery. I haven't had an opportunity to look into that, Judge, but obviously one's a second degree, one's a, big deal.
All right, so counsel, I know that they already say they have a placement for your client, but do you want to recall this so that the state can look into what perhaps you all can work out as far as the bond placement?
That's a good idea, Judge. Let's do that. I haven't had that opportunity because I'm not even sure if the case is indicted yet. It feels like it wants to be indicted, but
Okay.
I do need to look into any discovery the state would provide to us if they feel.
All right, so Mr. Lampkin, the placement is still going to be available. It's not going to go anywhere. And the people who are working with you are still going to work with you. But for me to set this bond, it would probably be best for you if the state and defense can communicate with each other, which I know they will, because they're people who communicate with each other, and come to perhaps maybe agreement. Maybe they can come to an agreement, maybe not. And then that perhaps could fast track you to where you need to be, which is in an inpatient facility, okay? What day?
How about a week from tomorrow?
All right,
Maybe I can get everything I need by June 10th.
All right, Ms. Ferguson, can you put this on June 10th?
Yes, ma'am.
All right, and Ms. Abrams, if you'll let them know that this is going to come back on June 10th. All right, thank you.
All right, thank you, Judge.
You're welcome.
Additionally, Judge, I've got one other client today, Leroy Smith. It's gonna be a plea, Judge. I can't be back this afternoon. And then else, can we recall it for tomorrow, for, can do the
Yes,
plea
and
tomorrow?
who is the person?
Leroy Smith?
I'll just have them pull the file.
Yeah.
Don't be talking.
All right, who is here on Michael Medellin?
There's one, Judge.
1:30.
Thank you.
Well, you know what, Norma?
Yes.
Put them at,
They're still working. They're having trouble with the printer as well.
all right, put them at 1:45.
1:45.
And he's here for sentencing, correct?
Yes, correct, Judge.
All right, the court is calling 2024 CR 0116992 State versus Michael Medellin. Can I have parties and
Orlando Gastagnon for defense.
and are you Mr. Medellin?
Yes, ma'am.
All right, counsel, we're here for sentencing. He entered a plea of guilty. The state waived count 2. There was a PSI and TAP evaluation report prepared. Have both parties had a chance to review the PSI state?
Yes.
Defense?
Yes, Judge.
Any objections?
No, Judge.
All right, the state is recommending deferred adjudication. Is there anything you wish to say on behalf of your client?
So I did read the pre-sentence investigation report. My understanding is that there was, I guess, a scheduling of for a mental health evaluation assessment. My client understood that that was voluntary or optional. And so he did not attend that. Part of that recommendation I saw in the PSI.
Well, I note that the request is for a PSI and TAP evaluation, I believe. Maybe after they completed the TAP evaluation or interviewed him with the PSI, then they wanted to see about a mental health evaluation.
Right. And so I don't think he's opposed necessarily to have that evaluation done, but I think at that time he was saying, well, I thought it was optional. And so he did not go to that scheduled event. In regards to the pre-sentence investigation report, I understand that there's some recommendations in there. I believe that he's admitted to consuming alcohol and consuming cannabis. That it does not seem as he's consuming either of those on a daily
If you're
basis.
drug tested today, what are the results gonna be
No,
for everything?
no, just the, material.
All right.
And so, it was saying in.
Is that with a prescription?
Excuse me?
Is it with a prescription?
No, Your Honor.
Okay.
That the recommendations when the TAF values for DDRF, I don't believe that it's necessarily appropriate at this point. One, there's no evaluation, but it also says if not accepted in that program to do a SATIF or ISF, one of those, and because of the usage, the level is not high. We're not talking about other substances outside of those two. I believe that more appropriately an outpatient program would be, I think, more appropriate. And we'd ask that you just follow this plea agreement. The complaining witness in the pre-sentence investigation report did say that she did not have a problem with the plea agreement. She's not seeking, there's not any restitution. She also said that she wasn't injured. And I believe that this is a fair agreement. We just ask that you follow it.
All right. Are you employed? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Michael Anthony Medellin.
All right, and Deputy Laura,
Yes, Judge.
they can start going back. We're gonna bring the jury in after this.
Yeah, come on.
All right. What do you do for work?
Right now, I don't have a job here.
How do you support yourself?
Right now, I'm doing freelance, but also retaining or getting help from my mother and my girlfriend.
All right, so you need to stop getting help from your mother and your girlfriend if you're gonna be using marijuana. You understand?
Yes, Your Honor.
Do you have any children?
I have one on the way, Your Honor.
Okay. And marijuana smells bad. You understand that?
Yes, Your Honor.
So you shouldn't be smelling like marijuana so that your child doesn't end up smelling like marijuana. When children are born,
No, hold on.
their brains, they're being developed, right? And their brains are developing. So doing all of these outside things, drugs or anything of that nature, that negatively impacts the development of the brain. You understand?
Yes, ma'am, I understand.
All right, so this is what the court is going to do. 8 years deferred adjudication, restitution, and no contact with Samantha Sandoval. If they say there's no restitution, there will be none. Regular reporting by Zoom or in person, regular random UAs. I want levels tested. If the levels increase, motion to revoke is going to be filed. I'll start with intensive outpatient treatment. There's be a $2,000 fine that will be prorated. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's going to be 200 hours of community service restitution. 100 hours to be deducted upon completion of the healthy relationship course. And the remaining 100 hours once parenting classes are completed. Field visits 1 time per month until further notice. There's to be 60 sober meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
I don't believe so, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue with something, let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court to address it. You understand?
Yes, sir.
And you're gonna have to get a real job. And when I say a real job, I understand this is your dream, whatever you're doing, that's your dream. But your child can't go from paycheck to paycheck, or maybe you have a job, maybe you don't have a job. You understand?
Yes, sir.
All right, good luck to you.
Thank you.
You're welcome.
Judge,
Hmm?
is this the original?
Yes.
Okay, you're retaining the copy of this?
No, I have an original as well. There are 2 originals because they don't have any trial court certification forms.
Okay.
So I
see.
have
didn't
mine
notice
as,
it. Okay.
yeah, so I
didn't
have mine as well.
recall. Thank you, Judge.
You're
Can
welcome.
we be excused?
Yes, you may be excused. All right, who's here on Cynthia Diano? Hi, okay, so what is happening with this case?
We have we turned in our plea paperwork, Your Honor.
Yes. And are you all ready to proceed? Let me. That always brightens the day. And then her son is graduating the academy. I'm like, oh. All right, could I have a file stamp for a plea, please?
Oh, sorry.
No problem.
Gotta get back into the.
The court is calling 2025 CR 0011146 State versus Cynthia Diano. Could I have parties announced for the record?
Defendant for the state of Texas.
Your Honor, Jeffrey Martinez for defendant.
And are you Cynthia Diano?
Yes,
How do you pronounce your last name?
again.
I got it right. Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Diano, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will be reducing this charge to a misdemeanor DUI and will proceed with that charge.
Any objection?
No.
Deputy Laura, Deputy Mejia, can you move them to that other end? All right, we're back on the record. Ms. Diano, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes,
Did you understand the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor? Range of punishment is anywhere from up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Oh, you didn't understand that part?
so,
Well, so let me explain to you. And then if you don't understand, let me know. I'll help you and your attorney discuss it. So you're entering into a plea bargain agreement with the state. You understand that part? Whatever agreement that you have worked out with the state, I don't have to follow that agreement. So let's hypothetically say they want you to have probation. If I were to tell you, I'm not going to give you probation, I'm sending you to jail, then you can withdraw your plea.
Okay.
Because I have not followed your plea bargain agreement. Now, the conditions for the plea bargain agreement, that's something the court gets to decide. You understand? So if for some reason I don't follow your plea bargain agreement and I try to give you more than what you've bargained for, then you get to withdraw your plea. And it can't be used against you if you decide to go to jury trial. You understand? And by that same token, if I don't follow your plea, then what can end up happening if you withdraw your plea, then the state can say, okay, we're going to have to go to jury trial. We're going to go to jury trial. And maybe they won't be going to jury trial on a Class A misdemeanor. They'll be going to trial on the injury to the elderly. Not maybe, that's what they'd have to do. You understand? All right, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into this plea bargain agreement?
yes,
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason you were to violate your conditions of probation, I could revoke you and sentence you up to 1 year in the Bexar County Jail. Did you understand?
yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Diano, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. There's a $500 fine. The state is recommending deferred adjudication. And there's no contact with several people. And there's a Samantha with a question mark by it.
Ms. Jones prepared this, I don't know why I did that.
Did you understand that to be your plea bargain agreement?
Yeah, but that lady actually has already assaulted me twice at my.
All right, so here's the thing. The only thing I'm looking at today is once I've gone over the admonishments for you and what your rights are, then what will end up happening is the state will present evidence and then I'll make a decision on whether or not that evidence is sufficient to find you guilty. If I find that the evidence is not sufficient to find you guilty, then I'm going to find you not guilty and say that the state can prove its case. However, if there's something else going on between you and this other person, that is not before this court today. That's something else. So what I've just read to you, did you understand that to be the plea? Defense?
Yes, sir.
State?
That is a plea.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there been such motions?
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 months. There be 30 hours of community service restitution, TAP evaluation, follow recommendation, sober meetings, random UAs, and anger management. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense of assault bodily injury as a class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
The honor defense is no judge.
All right, and state, have you spoken with the complainant?
We have.
All right, thank you. State, you may be excused.
Yeah.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it?
Yeah.
In all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We would like to.
All right, explain to me what's an in knocked? That's in the, that's in the police report. The officer said suspect 1 stated that victim 1 had in knocked on her door.
And they knocked on their door trying to.
No, I'm asking.
Constantly.
No. What is an in knock?
Nigger knocking,
Yeah, what is that?
going and knocking on a door and running. and
But why
running
is it
away.
nigger knocking?
That's what. they
Why
call
isn't it
If-
Caucasian
if it's
knocking?
a
Why isn't,
word,
no,
it's
no,
a
no.
word in the-
Why isn't it Caucasian knocking? Why isn't Asian knocking? Why isn't some other knocking? Why is it called
I
that?
don't know, that's just the way they say it. I
No,
mean,
that's the way you say it because that's what you said.
That's what I just, that's basically, I mean, all right. I don't know what else to tell you.
No, I'm just trying to figure out why
It's
would
not
you
like a
call it
race,
that?
it wasn't to be racist. The kids just kept knocking and knocking on my door, constantly doing that to me. They live upstairs. I did not touch this kid, and I really don't even want to sit here and plead to say that I did.
Oh, you can go, we can have a jury trial.
I don't want to do that because he says that's not the best thing to do.
No. Here's the
I
thing.
just lost, look, I lost a child. My son was 19 years old, was murdered just 2 years ago. I'm under a lot of stress already, you know? So I'm just trying to get out of this and get it as easy as,
Just what?
I'm just stressed out enough,
Mhm.
all right?
So do you want a jury trial?
No, I don't. I just want to get this over with, do the probation and whatever I have to do.
All right, so what was the race
I
of,
don't understand when you asked me that question. If you knew the
Yeah.
answer to the question.
what is the race of the complainant?
Hispanic.
Hispanic.
Everyone's Hispanic in the instance.
Mhm. And what do you, if I knew the answer, I don't know why you would say that. That's why I'm trying to figure out why you're saying it, because in the police report, they say you were intoxicated. So I'm trying to figure out,
Intoxicated.
that's what it says in the police report. It says suspect stated V had knocked on her door and she came outside to see who knocked. And victim's family came down the stairs yelling at her, accused her of hitting the victim. Suspect kept saying she did not want to tell her side of the story and tried to walk away to go inside. I detained suspect to investigate further. And it says in here that there was signs of drinking.
I don't see a crime in drinking in your own home. I was in my own
I'm
home.
just trying to figure out what's going on because I have to set conditions for you. Is this an anger problem? Because they want you to do.
I just, I'm sorry that you caught me off guard with the question that you asked me. I feel like you're kind of in a setup, I felt kind of set up with that question. I understand it's not a word to be used, and I understand that I used it in the wrong word, in a wrong way, and I apologize for that. So I'm sorry.
There's more in here that you said. You're using profanity. I am trying to figure out, because it says suspect had a strong odor of intoxicants on her. I'm trying to figure out why the state is asking for anger management, because they're requesting that you do anger management. They're requesting that you have a TAP evaluation to see if you have a drug or alcohol problem. They're asking for sober support meetings. Sober support meetings are usually for people who have a drug or alcohol problem. I'm trying to figure out what's going on because you told me that the lady, Samantha, had, assaulted you or is still causing problems with you. So I'm trying to read the room and figure out what's going on, and I cannot.
I'm leaving this apartment, so I'm already have gone into a new place to live. I'm leaving on Sunday because the lady kicked my dog the other day and she got up in my face and stuck her finger in my face and started yelling at me. No, I don't have a drinking problem. Yes, I lost my child on February 5th, 2023. He was murdered by a best friend in a gas station in Austin, Texas. And I lost my fiance 11 days before that. He had a heart attack inside my home. I've been under a lot of stress and frustration. These people don't leave me alone from upstairs. It's a constant fight with this lady. So I'm moving myself away from that environment. I've already lost my job because of her, that I had a job with for 6 years, working from home. And I politely went upstairs and told her, look, I work from home. All they do is they run like a herd of elephants upstairs and it basically just annoying people. And that's it. The kid just keeps knocking on my door. They would steal my decorations from my home. I've already complained. So now I'm taking myself out of the environment and just going somewhere else.
All right, state, you're requesting anger management and sober meetings? All right, and why are you requesting that?
Seems like that would be beneficial for the defendant to undergo.
We're in agreement with the state. We would have to probate the fine, Your Honor. As you heard, the defendant has lost her job. She's having to have moving expenses. She's indigent and court appointed, Your Honors. At this time, we would ask to follow the plea and to waive the fine.
So you're fine with anger management and sober meetings?
Yes, Your
Okay. There's going to be a $500 fine probated, proof of employment within 30 days, no employment as a home healthcare provider or with minors. There's going to be 1 year deferred adjudication, 80 hours of community service restitution. I think she needs anger management. I'm going to order anger management. Once she's completed that, then 40 of the hours will be deemed satisfied. And then I'm going to order 60 sober meetings in 60 days. TAP evaluation, that can be out of custody. Follow recommendations. There's going to be field visits 1 time per month for 6 months. Regular reporting by Zoom or in person, regular random UAs. There's to be no contact with the following persons: Danny Ibarra, Samantha Coronado, and Brenda Espinoza. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and Ms. Abrams, see if maybe a referral to Center for Healthcare Services, maybe they can help her with any type of trauma. All right, thank you.
Thank you.
I'm like, okay. Dinesha Walton. Hi, I did see her by Zoom.
Did speak with Steve Spear this morning.
Mm-hmm.
He did provide me with the discovery last week.
So no discovery issues?
No, none at this time.
All right, and were you given an offer?
Not a complete offer. It's
Okay.
It's something we're trying to work on.
All right, and when did you say you're gonna be back in town?
I'll be back on August 11th.
All right. So for this one, Norma, on Dinesha Walton, can you put a plea deadline date for them for August? Is August 14th good for you?
That's fine.
If you could put their plea deadline date for August 14th?
Yes, ma'am.
All right, thank you.
Thank you, Judge. And did you want to speak to Miss Essex?
Yes. Oh, well, just let her, Miss Essex, if you'll come down, please. Hello.
I apologize about Thursday.
No.
No, I feel really bad. I'm sorry. Please forgive me.
Apology accepted.
Okay, thank you.
But I will tell you, I don't hold grudges. When something happens, it goes from my mind.
It was the medications that came at 2:30 in the morning, and once it's sleep aid, I was just kind of, I'm telling you, just truth. And I don't know why they came that late. You called me out at 3 and I was like kind of groggy or whatever. I just wanted to state it because it was disrespectful.
All right, well, just make sure you understand that when, okay. All right, so what we're gonna do is your counsel in the state, they're still reviewing a couple of things, so then I have you brought back on June 26th, okay?
Okay, thank you so
All
much.
right,
I
you're welcome.
appreciate it.
Thank you.
Sorry again.
Oh, no problem.
I'll see you again. Thank you.
Thank you, Judge. May I be excused?
Yes,
May I be excused?
they'll take you back. Court is calling 2024 CR 5390, State versus George Hawkins III. Could I have parties announce?
Andrew Harrison, state.
Grant Hardy for the defendant.
Are you Mr. Hawkins?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same George Laverne Hawkins III who was placed on deferred adjudication in 2024 CR 5390 for the offense of assault on a peace officer or judge on August 8, 2024 for a period of 8 years? Is that you?
Yes.
All right, state, you may proceed.
On or about the 30th day, April 2025, in Bear County, Texas, the defendant George Laverne Hawkins III committed the offense of criminal trespass and violation.
How do you plead to that? True or not true?
State waives the remaining violation allegation.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge. Deny the motion, alter and amend. State will take into consideration submissively new Offense, although we request a no contact order with Cross Towers located at 111 West Houston Street.
And what is the cause number?
2025 CC 006392.
All right, counsel, is that the agreement?
It is, Judge.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
George Laverne Hawkins III.
All right, so why were you at Frost?
Well, it began whenever I relapsed. I was a year sober on methamphetamines.
Mhm.
I was in drug court. I actually wrote a letter to explain it all to you.
Mhm.
You would like to see that, but I could explain it in words.
Sure.
So, I was actually doing really good in drug court, and it kind of took me by shock whenever the district attorney in drug court, put in the motion to revoke, because I had been a year sober. I had been going to all the meetings. I was in Rosetta Keys, going to groups 2 times a week, and also the individual sessions with Tammy Banfield, and also I was seeing the judge during his sessions each month, and I was also seeing Elsa Guajardo
All
over
right,
at.
so there has to be more going on, because felony drug court would not put you out of their program just because you started using again. So there's something, what else is going on?
I did make a few slight mistakes whenever I was in drug court.
It takes, let me just tell you, it takes more than that. So let me explain something to you. I am trying to decide whether or not to follow this agreement that's been reached with the state and the defense.
Mhm.
Now, I don't have to follow it because your contract is not with them, it's with the court. I could sentence you to 20 years. But I'm trying to figure out what's going on with you and why you were put out of felony drug court. And what I can tell you, because I've been an attorney in felony drug court, they do not put people out of the program because you relapsed. They do not put you out of the program because you're making bad choices here or there. What they try to do is they try to correct those issues. Now, if you disappeared on them, they only have so much time that they can allow you to be on a warrant and you've disappeared.
Yeah.
So there has to have been something else going on other than you relapsed and you made some bad choices here or there. So why do you feel that they put you out of the program?
You're probably not gonna, you.
No, I mean, at the end, let me just tell you, at the
My
end,
belief is because the district attorney changed from what the bailiffs in the courtroom and Judge Glenn's courtroom told me. She had only been there for a month.
Mhm.
So she wasn't able to actually see my progression throughout the process while I was in drug court for 8 months. I mean, I was at Lifetime for 3 of those months. I've been going to Judge Glenn's courtroom as required, and going to my meetings with Elsa as required, going to my meetings with Tammy Banfield as required. And with the exception of two misuse, the last one being the close to the 30th there, whenever I relapsed. And also showing up late to my probation officer.
Mhm.
Those were the few mistakes that I made. I mean,
because usually they give you some options. They tell you, look,
I thought
we're going to try this last time, but we're going to do zero tolerance with you, or there's something else. So you're telling me this is all that's going on with them?
it baffled me as well. I was kind of speechless whenever I left there. And, I wasn't on my medication because I just had gotten, but from what I gathered, it all just seemed very confusing to me. I don't understand why they decided to, because the last thing I heard from Elsa Guajardo,
Mhm.
she from meetings going to 2 times a month, she switched it to 1 day a month.
Mhm.
She said, because I've been doing so well. And the same thing with Tammy Banfield. she gave me less meetings, group meetings than the other peers in my group because I was doing so well. She even called me one of her best students, and I was on page 7, or I was on the 7th step out of the 12 steps of the MRT book. And I even got housing at the VA, residential housing at the GI Forum. And I mean, I was doing well, but all of it, that the one relapse, that did mess me up because I ended up losing my housing at the GI Forum, and which led me to going to the bank. I mean, I had tried so many places to get water, and then I was just, I had gotten sprayed in the face with mace because I was sleeping outside of a hospital because I got kicked out of the GI. Really, it's just I've been struggling with the addiction, with not having a job, which I attribute, the fact that I was able to get a job to drug court. Drug court did help me a lot, and Lifetime helped me a lot, which is kind of surprising why I was offered Lifetime again, which I would really like the opportunity to do that because I think they did well, especially Darnell over there at Lifetime Recovery, and they also helped me get my identification straight. They even got my driver's license back and all my IDs, and they put me in the door to housing, and it was just a great help to me. And I mean, I don't understand. I even saw you at the graduation ceremony. It was nice seeing you there as well. And I had gotten a job. I hadn't had a job in 2 years. I'd been unemployed, but I did end up getting a job just by looking at the bulletin board in drug court.
All right, so just one second.
Yeah.
Ms. Abrams, do you know why he was released from felony drug court?
Judge, it states on here, he had that new charge. It was a new offense on 5/1/2025, and then on 5/14, he admitted relapsing. So that new number 1 automatic kind of brings it back to us.
All right, so it's the new number 1 and not just the relapse, because I know felony drug court would not put you out of program for a relapse, because sometimes. Oh, myself? Oh, since the very beginning, since its inception. And I was there as a defense attorney for that full time until I joined the DA's office.
Right.
Yeah, so years upon years upon years.
Yeah.
All right, so then if the state is taking care of the new number 1, Ms. Abrams, can we see if felony drug court will accept him back?
Judge, I was actually pulled up program manager, but she doesn't be online. If you give me a moment.
All right, just have a seat. We're gonna see. All right.
Thanks.
You're welcome.
Thank you, Judge.
You're welcome.
We want to report to the court just our status.
Okay.
Yeah.
Yes.
So with regard to Mr. Howie, I've conferred extensively with the pro tem prosecutors. We're looking for some mental health services for Mr. Howie. And to this date, we haven't found anything that we think is exactly what we're looking for, or close enough to what we're looking for. I was formed of a new program that your clerk actually found in her available programs. So I'm going to go ahead and follow up with that.
All right, so how much time are you asking?
If we could, honestly, if we could come back next week, Judge, on this case,
Okay.
because the fact of the matter is, the state's not looking for revocation in this case. We're looking for, we want to address Mr. Howie's mental health.
Okay.
So in that respect, if this program works out and it's something that we believe kind of fits what we're looking for, then we might be able to get this done sooner rather than later.
All right, you want to bring it back on June 9th?
That would be great, Judge.
All right, Mr. Howie, we're going to bring you back on June 9th. All right. Defense, I don't know if this agreement will work out. I forward I forwarded to Miss Abrams what they're saying. So the email that I have, what do you think the email is saying? Well, let's start with this. Did you abscond from the sober living house, yes or no?
No.
Oh, okay. Then we're gonna need people here because it says Mr. Hawkins absconded and left the sober living house he was staying at.
What exactly is abscond? To run away from? I didn't.
You left and you did not return. Did you
They
leave?
kicked me out. They packed my bags
Mm.
and left them on the front hallway.
No, that's not what's saying here. And then,
Wait, okay, the sober living home, which one? Because I was at a sober living house.
well, let me ask you this. Did you ever leave a sober living home, a sober living house, and not return?
The one at 14823 Bending Point Drive, the one that I went
Now,
to.
my question is, did you ever leave? See, this is the problem. When people are in their drug addiction,
I was asked.
they want you to be very, if you're not specific with your words, then there's a lot of wiggle room. And I'm getting a lot of wiggle room from you. So let me just end it right here. They said that you left, absconded, you left the sober living home, you did not return. That's what they mean by absconded. You were not supposed to leave there and not return. You left and didn't return. Then they said you had this major relapse. Then after you had the major relapse, you pick up a new charge. Then they still don't want to kick you out because I've been in felony drug court and I knew they just wouldn't kick him out for a relapse or even leaving the sober living house because sometimes that happens. Sometimes people don't do the program perfectly. That's why you're there. Then they said they offered you residential treatment and you refused to follow the plan set forth by the judge.
I'm speechless again. I mean,
No, I'm not, because that's what it says. I don't think Judge Glenn would be dishonest about saying that they offered you residential treatment and you turned it down.
I don't remember that. But then again, Your Honor, I wasn't on any medication when they questioned me.
And do you remember leaving the sober living home
That
and
part,
not returning
it
and
was,
then drinking yourself into oblivion?
it was the American GI Forum. I did go out without requesting to go out.
And you never returned.
I came back the next day.
Mm.
And then when I came back, I stayed there for like 2 days and then they told me I had to leave.
No, they said you absconded, you left, you never returned.
The staff at the GI Forum told me I had to leave.
And then they offered you residential treatment and you declined.
They as in drug court, that part I don't.
He refused to follow the plan set by the judge.
I don't remember a plan, but then again, I forget things because like I'm heavily medicated.
See, that is the thing. This is what I tell everybody. When people are in the throes of their addiction, the stories they tell sound so true. Like when he stands up here and he told me, he said, I was doing great. I just had this one relapse. I don't understand what the issue is.
But
now we understand that it was more than just the one relapse, which is what I thought. It was you leaving the sober living home. And even I've been in drug court before where people have left their sober living homes because they go back, they have a relapse, and then everybody's working, trying to get them back into compliance by trying to, probation officers go to their old hangouts. They even will, if somebody used to hang on a corner, they'll even go to that corner, ask people around, hey, have you seen this person? Because they are desperately trying to get that person back into compliance, back clean and sober, because that's what they want. So I knew that there had to be something else going on. If it was just this one time, I was doing so great, then I relapsed. No. And then even though you absconded from the sober house, even though you relapsed, they still wanted to work with you and they wanted to put you in residential treatment. It was offered to you and they came up with a plan. What I do know is sometimes when people are in the throes of their addiction, they want to make their own plan. And I tell them, you can make your own plan.
Your Honor, one way to make sure that this is accurate would be to just call GI Forum and ask them what happened. They would say they kicked me out.
No, I
did not
want to
have
talk,
stopped.
here's the thing. That whole thing about the sober living house, that whole thing about your relapsing, that's not even the big picture. You know why? because felony drug court was still going to work with you. And they had set up a plan. They came up with a plan for you that involved residential treatment. And you said no.
I wasn't even on medication at that time when they questioned me with all these questions. I mean, I don't understand the law as well as y'all do.
See, so here's the thing. Now you're changing you're moving the goalposts. At first you're like, no, I never did it. I never turned down residential treatment. No residential treatment was never offered to me. And now we're on this kick where now you're saying, well, I don't understand all this legal things that are going on. The legal things that's going on when a judge tells you you absconded from the sober living house, you've relapsed, we're going to try to get you back in compliance by you're going to a residential treatment. And then you say, no, you're not following that plan. So counsel, here's the court's issue. Felony drug court wanted him in inpatient treatment. He said, no, there is nothing I can do for him. So if you all are coming before me and you all want me to follow this agreement you have where he goes into residential treatment, not going to happen because felony drug court has already offered him residential treatment. And he said, no, this is somebody who's writing his own plan. And now they want to come to me because this is sort of like the end of the line where felony drug court, now they're really serious because now I'm before this judge and my only choice is to go to inpatient. I'm not going to follow that because he was given the option to go to inpatient treatment. He didn't want to.
You know what occurred during that meeting with Judge Glenn? And Elsa Guajardo, I told her that the charge that I was initially in here for with Superior Court, Judge Boyd, was total bullshit. That the cop
So
lied.
here's the thing.
The cop lied.
Here's the thing. We're on the record. You are even going further afield of what we're here for. This whole thing, you were placed on probation out of this court in August. This whole thing that maybe this didn't happen, that ship has sailed because you entered a plea to it. You entered a plea of no contest. Stipulations were put in the record. I read them. I found that there was sufficient evidence to find you guilty and I placed you on deferred.
Did you watch
And
the
you
video?
can't, here's the thing, you keep moving the goalposts. You said the only thing that happened to you in felony drug court was you relapsed and you were doing so great and you didn't understand why they kicked you out of the program. Now we have this email that your attorney said, yes, please email them and see what's going on. Now I have an email that says you absconded from the sober living facility. And then you come back at me, oh no, I just left for the day and I came back and my bags were packed. And then we come to the point that you abscond from the sober living facility, then you relapse. And then I say, that's not even the issue with felony drug court because that's happened to people in felony drug court before. They still try to work with you. So then here's the third thing. You do all of that in felony drug court and felony drug court tells you, we will give you residential treatment. That's the plan. And you tell them no.
Okay, Your Honor. As far as the whole residential treatment, what you're referring to, the sober living facility, I stayed 1 month at a sober living house. That 1 month was up. The manager of the sober living house, he told me, you don't have a job right now, so you can't pay, so you get out. He packed up all my bags. I had to move. I moved into the American GI Forum. And around that date, April 30th, well, it was actually April 26th, I picked up and used. I used meth. I drank alcohol that night. I continued to do it for a couple of days. That night when I did pick up and use and I drank, I called the UA line that morning and they said, come into UA. When I did that, so at that point, I didn't make the UA. And then I went back to American GI Forum. And then at that point, they said, well, they figured out, they seemed to have thought I was high on meth or because I wasn't acting right and then all that. So I just kept myself in my room. I was using meth in my room with American GIs. I'm not lying. And they put two and two together. And then they said, you're going to have to leave here. I had no other place to go. At that point, I went out and slept on the street, at the church, at the Christus Hospital. I slept outside the hospital. A security guard came, sprayed me with mace in my face. Whenever I was asleep, and then I walked to the frost bank to get water, to get it out of my eyes. Did that work? No, I got arrested. That's where the criminal trustworthiness comes into play.
All right, so let's get to the point where, because according to the email, they say that you absconded and you left the sober living you were staying at. You know what? Let's assume that what you're telling me is the truth about that. Okay. They say the next thing you did was you drank yourself into oblivion and used meth and pick up a new charge. Okay. And this is what felony drug court is saying. Felony drug court's like, hey, he left the sober living home, did not return. You're saying you returned. Then he relapsed and he picked up a new charge. But you know what this email says? It says you left the sober living home, you relapsed, you picked up a new charge. Then after all of that, guess what felony drug court says? We don't want you out of program. We want to still work with you. And they come up with a plan. And that plan is for you to be in residential treatment, and you refuse to follow the plan. So this whole thing about you absconding from the sober living home, about your relapsing, about your picking up a new charge, that's not really the sole reason that you were released from felony drug court. The reason why you were expelled from felony drug court is because they had a plan for you, residential treatment, and you refused to go along with it. So now we're here, and what I can tell you is I'm not following this agreement because I can't help you. Drug court tried to help you with residential treatment, and you said no. So I'm going to find you guilty. I'm going to revoke. I'm taking in consideration 2025 CC 006392, give you credit for any time served. There's the therapeutic community. Is there any suggestion with regards to time? He's looking at 2 to 20 years.
Being familiar with the facts of the allegation. Cool.
All right, the underlying facts of the allegation, you can review the stipulation. The court remembers those, but I'll give you the stipulation. And counsel, if you would like to review the stipulations as well, you can. Okay.
Quite frankly, it seemed like he was a bit prejudiced whenever he said I drank myself into oblivion, because how would he have even known that? He didn't even do an alcohol test or blood test on
Are
me.
you saying you didn't drink alcohol?
Not into oblivion,
All right. How many drinks did you have?
enough to where I was still sober.
All right. And how much meth did you have? Was that enough till you were sober as well? Okay.
Yeah, you're on.
All right. So what are you recommending?
6 years.
Defense, are you in agreement to 6 years?
No, Judge, we'd ask for the minimum. Judge. By the officer's own admission, he wasn't seriously injured. I think thank you. Judge, I think reasonable people can disagree as to the defendant's intent at the time of the offense. So bearing that in mind, and given the fact, Judge, that this is his first felony, bearing all those into consideration, Judge, we'd ask for the minimum of 2 years.
All right, this is what the court will do. The court was, as previously stated, the court is finding number 1 true. The court will find you guilty, grant the motion. Take in consideration 2025 CC 006392. Give you credit for any time served. The court will request the therapeutic community. Doesn't increase the amount of time that you're in custody, but if you sign up for it and they accept it, it'll help you with your sobriety. And I'll sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Didn't read it, no.
Okay. Did you sign it?
I did.
All right. Well, what that is that's telling you whether or not you have a right to appeal. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion. not the fact that you were on deferred adjudication. You understand?
Limited as in what I can't appeal.
No, you'll have to speak to your attorney, but what I can tell you is this. You entered a plea of true to violation of condition number 1. The court found it true. You are allowed to appeal that finding of true. All right, so that's your limited right to appeal. You don't have a right to appeal that, hey, I shouldn't have been on deferred adjudication for this, because that time has elapsed. Do you understand?
So the incident with the police officer, I cannot appeal.
You need to speak to your attorney with that. I'm just talking to you about this specific process with regards to your motion to revoke. So with regards to your motion to revoke, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion in your plea of true. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. All right, good luck to you, sir. Thank you.
Thank you, Judge.
Oh, I'm sorry. Is that the last case we have?
Yes, ma'am.